the basis of fairness and unfairness, justness and unjustness. The mass idea about the law, their civic and political rights, and if these rights are violated, what will they do? And we will also keep to bring you such legal concept for you to be educated. And for tonight's episode, I have with me Mr. Ibrahim Bangura, Esquire of Legal Hour. Good evening and welcome to
Yes, good evening. How are you?
And I also have with me Mr. Macus Bangura, the Secretary General of the CSO Working Group on Epidemics. Good evening, sir, and welcome to Legal Hour.
Good evening, thank you for having me.
Yeah. As always, before we go down on our discussion, we used to have first our legal news. But our topic for this episode is the effects of public emergency in containing COVID-19 and taking into cognizance human rights. So of course we do have these perceptions and these different questions if the president has the power to declare emergency or public emergency could also be used as the only measure in containing the COVID-19. And some do say that basically it's just a means of how best their rights can be violated. So we are here to demystify some of these difficult concepts that you have been having out there and to get the real source. But first, let's have our legal news. And for this week, our legal news will be focused on an activity that was done by the Anti-Corruption Commission of Sierra Leone, in which it was successful to secure a conviction against one Mohammed Sharif, the former MD of Salcab, for corruption offenses on 1 count and 3 counts respectively. Let's just take a look. One of the most famous, the Anti-Corruption Commission wishes to inform the general public that the High Court of Sierra Leone, holding in Freetown, presided over by the Honorable Justice Miata M. Samba, has on the 8th of April 2020 convicted Mohammed Sharif, former Managing Director of Sierra Leone Cable Network SALCAB, and Paul Sandy, former Permanent Secretary of the Ministry of Information and Communication, on 1 count and 3 counts of corruption offences, respectively. Honorable Justice Miata Samba ruled that Mr. Paul Sandy pays a fine of 120 million yuans on all 3 counts, and Mr. Mohammed Sharif is to pay a fine of 60 million yuans on the 1 count. The fines are to be paid immediately before their release or serve a jail term of 3 years. Mr. Idris Aguilar, on the other hand, was acquitted and discharged. On all 3 counts he was charged. Mr. Paul Sandy, Mr. Mohammed Sharif, and Mr. Idris Aguilar were standing trial for various corruption offences, including misappropriation of public funds, contrary to Section 36, subsection 1, failure to comply with applicable rules and guidelines relating to the management of public funds, contrary to Section 48, subsection 2, paragraph B, and conspiracy to commit a corruption offence, contrary to Section 128, subsection 1 of the Anti-Corruption Act No. 12 of 2008. The 3 persons were accused of misappropriating public funds amounting to $300,000 US. On another note, the High Court of Sierra Leone, presided over by Honorable Justice Miata M. Samba, in another judgment acquitted and discharged Ali Badara Mansare, former Commissioner, National Commission for Social Action (NACSA), on 15 counts of various corruption offences. The Commission wishes to reassure the people of Sierra Leone of its relentless commitment in curbing impunity in public service. For FTN's Legal News, Bakarr Marrah reporting. Welcome back to the Legal Hour with Marrah on Freetown Television Network, Channel 35. Tonight's episode, our topic that will be discussed upon by my proficient guest is the effect of public emergency in containing COVID-19, taking into cognizance human rights. And based on the topic, we are going to have a sensical elaboration by my guests who are here with me. So I want to start with Mr. Gavos, who is the Secretary General of the CSO Working Group on the Epidemics. So based on the topic, so how do you view it?
It's a very, very important topic because it's necessary for the people out there, I mean the public, to have a first-class understanding about the public emergency as to whether human rights issues infringe upon it. In the first place, Section 29 of our Constitution stated that or empower the President to declare a state of emergency. That is a right given to the president because the constitution in the first place is sacred and it is sacrosanct, and as a result of that, it is incumbent upon all Sierra Leoneans to adhere to the provisions of the constitution. So as a result of that, section 29(1) provided that the president could declare a state of emergency, and subsection 2 gave the determinants, that is to say, the circumstances under which the president could declare a state of emergency or may declare a state of emergency. State of emergency, as provided by our constitution, the president can declare it whenever there is a threat of war, or when the country is caught in a situation wherein there is a tendency for it to be invaded, right? That is aggression, or whether there is internal disorder, understand? And again, if there is any other imminent danger that has the likelihood to affect the welfare of the well-being of the people, say in the situation of health matters. So as a result of that, it was the responsibility of the president to actually declare the state of emergency when one take into consideration of COVID-19 and its virulent effect, its devastating effect that it has caused globally. So as a result of that, in an effort to control it or to contain it, there is a need for the president to actually declare a state of emergency. However, that is not to say that the state of emergency that has been declared should not be regulated in a way that will protect the rights of individuals in society. In the first place, it is the responsibility of any government to protect the liberty of individuals within the state. It is the responsibility of every government to protect the property of individuals within the state, as well as the life of individuals within the state. But there are certain times, though Chapter 3, Section 15 of the 1991 Constitution gave fundamental human rights and freedoms to individuals within a state. But there are certain times, because of certain reasons, these rights can be curtailed. These rights can be restricted, as it is at the moment. We have been enjoying our rights, but as a result of the fact that there is COVID-19 and the threat of COVID-19, and in an effort to mitigate it, or to mitigate the chain of transmission, then the president thought it fit and wise, because the constitution gave him the power, that in his own opinion, when he is of the opinion that a particular situation has the proclivity to actually degenerate into danger, understand, he may come up with a state of emergency. So the state of emergency is good that it has been passed. But again, I just want to look at the United Nations, right? You have states, you have certain bodies, we call them body rights of the United Nations. For example, the rights of...
All right, now let me just hold it there before you delve into the UN. Let me come to Mr. Bangura. We've heard from Mr. Macus of the CSO working group on this epidemic.
Yes.
Now, take a look at this public emergency, which is used as a stringent measure to say best we can contain this COVID-19.
Yes.
So, do you see it as just the only way we can contain COVID-19 in Sierra Leone?
Well, safe to say, it might not be the only way, but one of the most effective and efficient ways of containing or controlling the COVID-19. First of all, before I go further, I may like to educate the public or the listeners on what is meant by a state of emergency. A state of emergency is a situation wherein the fundamental rights and freedoms which the Constitution provides for citizens of a state are being suspended. In such a situation, the president, in his own opinion, once he deems it expedient, necessary, and fit, may bring out regulations and policies which may pass as laws. They are properly legal, so to speak. It is not an illegality in itself. But a state of emergency in this situation is very appropriate in the sense that The fight against COVID-19, mind you, is a global pandemic. It's not only a national pandemic, it's a global one. Taking, for instance, bigger nations and more powerful nations, the like of China, America, Italy, and a host of other bigger nations. We have been seen on television and we have been hearing about on news. We can realize that those countries are suffering. People are dying every day. And yet, why are we supposed to question the declaration of a public state of emergency?
Well, I believe
by His
many
Excellency?
people how they have been questioning the declaration of public emergency. Reason being, it wasn't declared based on its normal protocols. For example, I guess Section 29 of the Constitution, subsection 5 states
Yes,
that there must be measures, regulations being
Yes,
put
in
forth.
fact,
And
that
these
is
regulations
where,
have not been seen.
in fact, that is
So
where,
it seems to be illegal somehow.
yes, that is where the problem is. Because, as I mentioned earlier, Section 29(1) empowered the president to declare a state of emergency. Then, Section 2 gave the determinants as to the reasons why the state of emergency should be passed. You understand? And when you go to Section 5, you understand, of the Constitution, it says that whenever a state of emergency is passed, there should be regulations which the president should present to Parliament, and Parliament should debate it, and after they have debated it, and they take a vote, and there should be a two-thirds majority of the votes. But in this situation, I was in Parliament when the Attorney General Minister of Justice made a submission, and members of Parliament, we are curious to say that the president, or it should be followed by regulations. And there was a promise made by the Attorney General Minister of Justice, and they agreed that within 14 days, the regulations should be submitted. It is clear that whatever the circumstances, although the president is empowered by law to declare a state of emergency, and we should take into consideration of the fact that it is the law that empowered him to do so. And in as much as it is the law that empowered him to do so, he should also abide by the rules and regulations, the provisions of the Constitution. Because if there are no regulations, then how could the people understand the laws that will be passed? Because the reason why rules and regulations are passed, they are passed to define the situation. The rules passed should be in conformity to address the issue at hand. This is a public health emergency. You understand? So as a result of that, why was it passed in the first place? The law was passed in order, or the state of emergency was passed in order to mitigate the chain of transmission.
So I believe in such structure, one could say, without going through the rightful procedure, to establish...
It is questionable. That is where the question
that
is.
It just means to establish they can violate on the right of the country's citizens.
Yes.
Will that be said by one?
Yes, that one is verbatim. It's clear. You understand? That is why in my opening statement, because I believe the Constitution should be followed. Its provisions should be followed. And the Constitution provided in Section 29(1) that the president should pass a state of emergency. And in fact, when the president passes a state of emergency, it has powers within 7 days, and after 7 days it will expire. That is if Parliament is sitting. And in a situation wherein Parliament does not sit, it takes 21 days, and after that it expires. You understand? But there is this argument around it, because according to a press conference held at State House the other day, I saw the Attorney General and Minister of Justice saying that they have already made the regulations. And these regulations should be passed by Parliament. They should be submitted to Parliament, they debate it, and passed into law. So in a situation wherein the regulations are not taken to Parliament and passed, then I cannot say it is illegal, but we can question its legality.
Okay. Mr. Bangura, so being that the government actually did not go through the rightful procedure to declare a state of emergency, and now what in a situation we are in, maybe one of the citizens failed to comply with the rules. That, for example, we have recently locked down 3 days, and some we are beaten for actually going against such rule. So could that be seen as a disobedience towards the ordinance of the government, since they did not go through the rightful procedure of the law itself?
Well, I don't want to believe so. I may like to defeat that argument. Firstly, we are not here to debate or to talk on the legality or illegality of the state of emergency itself. What we are here to talk about is the impact of the state of emergency in the fight against the COVID-19. I verily believe that if, for instance, the government or the president says X, Y, or Z, and a citizen defies such, then they should be held wanting, because they are in defiance of the president,
hold on,
the regulations,
yeah,
and
they should be, but how could they be held punishable
yes,
for something
yes,
in which it can be questioned on its legality? So if the public emergency can be questioned on its legality basis,
then
how could they be held
if it can be questioned on its legality, then it's for the citizen or any member of the public to take it to the Supreme Court for interpretation. But what I'm saying now, as far as it is the situation now, we are in a public state of emergency. So, rights and privileges accorded to citizens in normal times, the president, in his own opinion, or through any government agency, department, or what have you, may formulate such policies or regulations which they deem fit and proper to fight against the pandemic.
Yeah, we know that, but we are trying to actually put out the acceptable standard in formulating such policies, structures, and
yes,
such.
But questions of legality are not here to comment on them. We all know where to take that. We have our court structure. You can go to the Supreme Court for remedy, for interpretation.
So, Mr. Macus, I think this is a confusing stuff for we citizens of Sierra Leone. If public emergency cannot be declared based on the law itself within the confines of the law, then we can claim that our right, like the freedom to conscience, movement, as seen in Section 24 of the Constitution, have been violated. Because if these procedures are not being adhered to based on the law, then it's like our rights have been violated.
The law is sacred. It is it's clear, and as a result of that, it is the responsibility of all of us Sierra Leoneans, irrespective of your status, be it the president or the least man, for us to abide to what the law dictates. The state of emergency is one thing, the law is another. A state without laws will be solitary, nasty, which is short, where everybody behaves as if. You understand? So, as a result of that, the Constitution is supreme. And inasmuch as it is supreme, it is this same Constitution that empowered the president to pass a state of emergency. Because under normal circumstances, the state of emergency should not be passed. Because when it is passed, it will encroach upon the rights and liberties of individuals within the state. But looking at the situation as it is, being that it deals with a pandemic that has caused threats that makes one heart to knock on his ribs. So as a result of that, reflecting on the Ebola and the devastating effect of the Ebola, you understand? And now we've got another pandemic. The government was very, very smart enough to say, let's have a state of emergency. It is acceptable for us to have a state of emergency, but what is not acceptable when the procedures that should be followed are ignored. You understand? Because in the first place, the president is empowered to pass a state of emergency for the general good of all, for the interest of the people of Sierra Leone, in terms of health-wise, in terms of security reasons, right? In terms of the peace, the harmony. You understand? That's why I said that every government is charged with the responsibility of protecting the rights and liberties of citizens, including life. So in the process of doing it, the president should take into consideration fundamental human rights. That is why the United Nations body rights, which comprise of 10 institutions that deals with rights, the committees, several committees, they have admonished government to ensure that whilst they come up with regulations or measures to tackle COVID-19, they should respect fundamental human rights. Right. So in this situation, right, we are not saying, I am not saying that the president does not have the authority, you understand, to actually declare a state of emergency. It is clear in the Constitution, and there is no argument about that. But there are procedures. Subsection 3, you understand, says that the president, you understand, 5 says that the president should submit the regulations that should be used under the state of emergency. So where the regulations are not passed, there is the likelihood that they will go ultravise the provisions, you understand, or the purpose for which the state of emergency is passed. And by so doing, it infringes upon the rights and liberties of individuals. So that is why it's simple. I'm just wondering why the government actually failed to adhere to subsection 5, what it says. You understand that they go through the constitution. You understand?
Alright, viewers, this is Legal Hour here on Filter Television Network, Channel 35 with me, Marrah, and our topic for tonight's episode is the effect of public emergency concerning COVID-19, taking into cognizance the human rights. And I have with me Mr. Ibrahim Bangura, Esquire, and also Macus, Mr. Macus Bangura, the Secretary General of the CSO Working Group on Pandemic. Let's go for a short break by taking one of our videos done by Yemata, who is also a law student of the Fabric College, on advising the precautions standard that can be taken in containing COVID-19. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law.
Corona, if you don't ask first before you come, people don't know how to answer. That did not mean anything. Lockdown, I realize how they can do. Don't use to that, they all. From us, not to anything that you do. Awesome. Focus you go down, level side they say from us to the last day. Corona. When I big brother Ebola, now in characteristics and they get was lockdown, don't use to run out. When I be clear, and the cow be the host, let me go inside.
Papa, to your Epsilon. Papa God, to your Epsilon. Papa, to your Epsilon.
Sweet Mama Salon, coronavirus one can bug we. But if we all come together and do what in Papa government tell we and the well body people them, we go them and go judges now. The well body people them say if we get sanitizer, let we the rubber now we hand fast. So if you get in your bag, now your pocket, any side they go they sanitize your hand. Then say again, if you not get sanitizer, before they use soap and water for wash your hand fast. And for wash some proper one. Let we left for the torture we face. Because on the inside and the coronavirus lek for bug we well body one. You safe within a house. Now for the clean inside them, we hand the church fast. Where you want for sneeze, no left and no more so. Sneeze under your elbow so that you not go and bug other person. Then we left the inside them with plenty people in there. We with man called social gathering. Because you don't know that don't go jam person. We don't touch other person where they can jam you. Coronavirus, na big sicko, let we not take and play. Do ya make we all join on with Papa government and the well body people them. If we do all waiting the well body people then tell we coronavirus, we go get a notice judges no. Fumble them. This message come out from the Sierra Leone Association of Comedians.
One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law because the law is made for you and you must know the law. Thus we bring you the Legal Hour. Actus nemini facit injuria. The act of the law does no one wrong, but uphold justice. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Welcome back, viewers, to Legal Hour here on Freetown Television Network, Channel 5 with me, Bakarr, Marrah, and for tonight, our topic is the effect of public emergency in containing COVID-19, taking into cognizance human rights. And I have with me two proficient guests, Mr. Ibrahim Bangura, Esquire, and also Mr. Macus Bangura, who is the Secretary General of the CSO Working Group on Epidemics. And we have discussed so well, and we have actually gotten to know about the legality or illegality of the public emergency, right? And some have been asking questions out there, what is the role of Parliament? Because if one is to assume that the declaration of this public emergency has not been legal, and thus one might not obey to such declaration, so what is the role of Parliament, being that they are representing the views, the interests of the people? Mr. Ibrahim.
Well, I believe the duties, the functions, or the roles of parliamentarians.
In terms of declaring public emergency.
Yes, in terms of declaring public emergency. For instance, if you go back again to section 29, subsection 13, section 29, subsection 13 of the 1991 Constitution, you will realize that, rightly said by my co-guest here, section 29, 1A and B, which provides for the president to make such a declaration in case of the sitting of parliament for 7 days and in any other case for 21 days. Parliament has that duty to extend such a period by a vote of 2/3 majority by authority of subsection 13. And the proceedings of Parliament, I'm not a parliamentarian, but I'm talking about the Constitution. They are supposed to represent the people. But however, let me tend to deviate a bit from your question. As I said earlier, Chapter 3 of the Constitution gives a lot of rights and freedoms to the individuals or citizens in this country. However, Section 29 tends to suspend all of those rights. I will give you an example. Section 29, subsection 5, in tandem with subsection 6. If you read those, you will agree with me that the president, assuming all legalities have been met, Parliament has done what they are supposed to do, the president has a right, has a power to make citizens, to make those regulations controlling the movement of citizens within defined localities, firstly, and has such power again to deport people, except citizens, from Sierra Leone in situations like this.
Okay.
So that tells you that Section 29 itself is very powerful.
All right.
Yes.
Yeah, but now let's say, how could Parliament authorize or approve such regulations or standards to regulate the state of emergency when those regulations or standards have not been given to them or actually been put in front of them?
Well, that again, to me, is a question for parliamentarians.
Okay.
Yes, we believe in our parliamentarians. That is why we, I believe, elected them into the offices to represent us.
All right.
So if they renege on their duties, I believe we should hold them to task.
All right. Mr. Macus, for the previous events based on this public emergency that is ongoing, we have actually noticed that and experienced that the right to conscience based on Section 24 of the Constitution that is to religion and also of movements, they have been restricted. And since such regulations have not been given to Parliament to approve, do you think Parliament has a role to play in see how best these rights can be upheld?
Parliament has a very important role to play. I always say a government is like a generator in a car. It is made up of different parts. And the absence of one part will not make the generator effective or an engine effective. Let's say a car needs fuel, needs plugs, and also need oil. If there is no oil, the tendency for the car to move, it will be very difficult. The engine will not be effective.
Yeah.
So as a result of that, the legislature, that's why we have the three organs, the executive, legislature, and the judiciary. And Parliament, by the Constitution, by the authority of the Constitution, is empowered to make laws in the land. You understand? So that is why even when the president is given power to make laws, is empowered to make laws, and he is still limited by the Parliament. You understand? Because there is these checks and balances. One organ has the responsibility to check the activities of the other organ. Otherwise, if the president just or the executive just go ahead and make laws, then it means that there is a tendency for them to make arbitrary laws. You understand? But when those laws or regulations are given to Parliament for them to look at, to scrutinize it, then debate on it, especially when they are representing different opinions, different political parties from different constituencies, you understand? They should look at it in a way that will reflect public opinion. That is why Parliament is there, you understand? So as a result of that, that is why the subsection 5 of section 29 also give powers to Parliament, gave Parliament the power to actually look at the regulations that the president has declared. You understand?
But being that there are no regulations, what should
But that is it.
Parliament do?
I'm just looking at the literal aspect of it. Literally, that is how it should be done.
Yeah.
Procedurally, that is how it should be done. It is sacrosanct. You understand that? That the government should work in conformity with the laws. That's why I said, if we had not have laws, the possibility for the president to declare a state of emergency, you understand, will have been difficult. But let's say it's easy, you understand? Say it was not going to be difficult because it's the president now. But we are operating under a democratic system of government, you understand? Wherein we need to actually nurse our democratization process. You understand? From 1996, we have gone on with it successfully. Although perhaps former governments have turned blind eyes and deaf ears to certain provisions of the Constitution. So if you say because of that, and you will take that particular route, then it's detrimental to the nation. Because even this government, when they came, they realized that the former government, you understand, has a lot of shortcomings. So that is why there was this new direction thing, that is to deviate from the old way of doing things, so that at least it will benefit the general good. So Parliament has a role. And now in this situation, to me, in my own opinion, you understand, it's like Parliament is being undermined to some extent because Parliament has a responsibility, you understand? And that is why it could have been easy for the regulations to be submitted. In the first place, it was 2 weeks. I understand because of the transmission chain. You understand? Perhaps if we can call Parliament again, perhaps it will be detrimental. But courts are still sitting. You understand? Is that also?
Yes.
Courts are still sitting, though it is restricted. So in that situation, even if you don't call all members of Parliament, there are leaders of Parliament. Each political party has a leader. In South Africa, what was done? You understand? They made regulations and other things through calls. You understand? Without them sitting together. But they were able to. We are living in a modern world. We are living in a well civilized world now, where things are so easy to make. So if they want to take that to be one of the factors why they have decided not to actually allow Parliament to sit back, because look at it, 14 days, and before the 14 days, there was this lockdown, making it on the 7th. I think the 7th should have been the 14 days that Parliament should have seated, and on that day, you understand what happened? It was a lockdown, thereby restricting Parliament to sit, and it is for the general good of all. You understand? So there comes the legality. You understand? A lot of people that are knowledgeable may want to question it. Other people out there will not question it. And our responsibility, in as much as we have it now, is for the people to understand first that the president has the authority, the local standard, to actually declare a state of emergency. Once he has declared the state of emergency, there are limitations to it, 7 days and 21 days. When Parliament sits, 7 days, it expires. You understand? So, what happens? The Parliament, because what they did was, they negotiated. I was in Parliament at that particular time. You understand? Because members of Parliament, we are not even ready, you understand, to accept that state of emergency thing. But they negotiated. And after the negotiation, they agreed that, let it be 14 days. They gave the Attorney General, Minister of Justice, or the government 14 days to submit the regulations. You understand? But the regulations have not been submitted, and yet we had the Attorney General, Minister of Justice says they already have regulations, and that regulations stands for about 90 days. Until after 90 days, you understand that if they want to invoke it or they want to add other regulations, then it comes up.
Thank you very much, Mr. Macus. Mr. Ibrahim Bangura. And basically, some people out there have been saying that when you actually expose those with notifiable disease like the COVID-19, it would be a crime, and others have been saying it will be a crime. So if you expose as a personal person and you know other person who has been suffering from such COVID-19 disease, do you have the right to expose the identity of that person?
Well, I believe the Constitution as well guarantees our right to privacy, firstly, and secondly, I believe for the medical practitioners, it is not ethical for them to indulge themselves in such. I mean, it's a different situation if I, for instance, God forbid, I contract COVID-19 and decide, and now decide to go public, say, oh, this is Mr. Ibrahim Bangura talking, I have XYZ. You understand? That is a very different situation. But as a medical practitioner, I go to you, you diagnose me and realize that I am positive. It is not for you to share what we should have in confidentiality to the public. It is against their ethics, I believe so. And once you do that, any damage which I may suffer as a result of your professional negligence, then you may accrue.
Yeah,
some
and I believe
legal
also
liability.
section 43 paragraph B of the Public Health Ordinance 1960 also support that fact that you shouldn't expose the identity of those who are infectious.
So over and above, I believe that the state has a responsibility or duty to protect the rights, the lives and property of its citizens. Say what you may, but these are times when the state should use all its resources, for security, all securities, you understand, to protect the lives of citizens. These are not normal times. We may discuss and we may talk on issues here, but these are not normal times. Very recently, we are made to understand that the number has increased astronomically to 43. So that will inform us that these are not normal times. So what I expect every citizen of the country now to do is to comply. Yes. The question of legality of parliamentary procedures, let's leave that for the court to decide. But into as far as fighting COVID-19,
I don't think there is an argument as to whether Parliament has the right to ask for regulations. I don't think there is an argument on that. Just that the government failed to do so. Understand? They failed to do so. But there is no argument. Because when there is an argument on interpretation of something,
I
you can
like
refer.
us to forgive our omissions
I
and
guess
failures.
The procedure.
So their omissions and
Yes,
failures
yes.
are forgivable.
Yes.
in this
And also,
crucial time.
Mr. Marcos, based on the CSO working group of this pandemic, you actually gave a report recently, and in your report you give several recommendations. And one of your objectives in your report was that it has to be transparent and accountable in concerning COVID-19. So when talking about transparency and accountability, how could that be further elaborated in concerning COVID-19?
The CSO working group for on epidemic and natural disasters is comprised of 30 civil society organizations, right? And it was formed as a result of the outburst of COVID-19, right? And especially when the president redoubled his efforts to ensure that we prevent it from actually eroding Sierra Leone. So that was the time we formed the organization to complement government efforts, you understand? And one of the objectives of the CSO working group is to enhance health accountability, understand? That is to say, we want a situation wherein finances directed, understand, on COVID-19 are used judiciously, understand? And also to ensure that at the end of the day, we come up with a report that should be transparent, that everybody will see and appreciate. And we did that. In fact, one of our recommendations was that aspect that has to do with the privacy of individuals. Of course, so we said that we want individuals that are infected with COVID-19 to be made known to the public. We have several reasons for that. I understand that they have rights to their privacy, understand? But again, we should take into consideration of the fact that we are under a state of emergency. And why is the state of emergency passed? Is to prevent the chain of transmission. And if we are obliged to actually mitigate the chain of transmission, then there is a need for individuals that are infected to be made known to the public for several reasons. Now, I am here with you guys, you understand? And let's say after 1 or 2 days, right, then I am positive, you understand? May Lord forbid, as my man said, you understand? But for clarity's sake, for people to understand, you understand, we are demystifying, right?
Yeah.
So in that situation, a lot of people that have, you know, associated with me, right, will begin to think that I was at that studio with Macus. So as a result of this, I want to be, I want the health authorities to check me. You understand? Because if it is not made known, perhaps I've interacted with more people. You understand? And there is a tendency for these people, you understand, perhaps during the process of interaction, you understand, perhaps they too must have been infected with it. And if my identity is not made known, then we are defeating the purpose of mitigating the chain of transmission. Understand? Okay. Because the first index case was made known. I did for yesterday, he went safely in his house and nobody intimidated him. You understand? So as a result of that, we don't want a situation, we want honesty. We don't want a situation where certain people are hidden. You understand? It will be detrimental to the state because of the interaction. You understand? And there is this aspect, when we talk about the precautionary measures, we have this social distance, you understand, which is very, very important. So as a result of that, if there is no social distancing, you understand, say where you have interacted with people at random, uncoordinatedly, it will be detrimental, not only to me, to the nation. Because the state of emergency says that the president can only declare it when there is imminent danger. You understand? Yeah. So there is imminent danger because when we take credence to overseas countries, you understand, and the devastating effect it has left in the minds and hearts of people. Every day people are dying. Yesterday, about 65 or 75 Sierra Leoneans, you understand, were buried in London. They were unidentified. The only way they could be identified was by their names. You understand? That if you are Kamara and this, they know that likelihood that you are from Sierra Leone.
All right,
so that's the situation.
This is Legal Hour here on Freetown Television Network, Channel 5 with me, welcome Marrah, and our topic being discussed here tonight is the effect of public emergency in containing COVID-19, taking into cognizance human rights. And I have with me Mr. Ibrahim Bangura, Esquire from the Legal Aid Board, and Mr. Macus Bangura, the Secretary General of the CSO Working Group on Epidemics and Natural Disaster. Let's go for a short break by taking one of our videos, which is the structure of the court system in UK, and the UK legal system is synonymous with that of Sierra Leone. So let's have a look of their court system, which we can also use to do a comparison with ours. Let's take a look.
In this lesson, we are going to consider the organization of courts in the UK. Now, as we considered in the previous lesson, the UK's court structure is hierarchical, as in you have a court of first instance or an original court and several appellate courts above that. It's interesting to note that there is an inverse relationship between the importance of case law that are taken up by these courts of law and the volume of cases that are in fact brought before court itself. So this particular graph actually notes that in terms of importance, the Supreme Court of the UK, which is the highest jurisdiction or the highest appellate court within the country, actually has a very limited number of cases in terms of volume, but the importance of those cases is great. As we noted earlier, appellate courts deals with matters of law and not that of facts. Whereas conversely, in terms of magistrates' courts, the volume of case law is greater, yet the importance in relation to appellate courts is somewhat lesser. The first court that we'll consider is the magistrates' court, or a first instance original court. The jurisdiction that a magistrates' court has is for minor criminal matters, for instance, petty theft, traffic offenses. It's not entitled, or it does not have the jurisdiction to hear serious offenses such as murder. However, there are instances where preliminary hearings are made for such serious offenses in order to see if there's a prima facie case to be heard, whether there are enough facts or enough evidence for a case to start proper. Next up, we'll consider the county court. Now, initially, following the magistrates' court, the immediate appellate jurisdiction was with the High Court. However, it was burdensome for the High Court to take in the excessive volume from the magistrates' court itself. Therefore, the county court came about as a stopgap measure, something that will ease the burden off of the High Court in terms of small matters. So in terms of the jurisdiction and the types of cases that a county court hears, they are much like magistrates' courts, minor civil cases. It's an original court of law, contractual cases which are less than £25,000, and geographically it's limited by its location, by where exactly this particular county court is. Conversely, this next court, which is the Crown Court, has no geographical limitation, and it sits in a variety of places. Now, this is the first instance that we see a connection between two courts of law, as in we considered earlier the magistrates' court having to actually see if there's a prima facie case in terms of a serious offense. These cases which the magistrates consider to have in fact a case to be heard is in fact forwarded to the Crown Court. Next up, one of the most important courts of law in terms of this original jurisdiction that we were considering in terms of the magistrates' court as well as the Crown Court is the High Court. And in terms of the volume of cases as well as the types that come about to the High Court, there is in fact three divisions. Firstly, there is the Queen's Bench division, which considers cases which do not go to the county court in the context of contracts or torts, mostly civil matters. Secondly, there is the Family Division, which, as the name itself implies, deals with matters concerning children and families. Finally, there's the Chancery Division, which pertains to matters concerning equitable principle. Now, mind you, these divisions are not set in stone. It is merely for administrative purposes that they have been divided in this way. Now, it's notable that if an individual wishes to challenge an administrative decision by the executive, then he or she should actually bring it to the Queen's Bench division of the High Court. The two top-tier appellate jurisdictions are enjoyed by the Court of Appeal and the Supreme Court, and therefore we will take a quick summary of the two of them together. The Court of Appeal divides itself into the Criminal Division and the Civil Division. The Criminal Division is headed by the Lord Chief Justice, and the Civil Division is headed by the Master of the Rolls. This is an exclusively appellate court, similar to the Supreme Court as well, which was established by the Supreme Court Act of 2009. Finally, two other courts of law that we must discuss is firstly the Privy Council, which is in fact a body established to advise the monarch on sovereign matters outside of the UK initially. It was the highest court of law, even for foreign colonies of the UK or jurisdictions outside that of the UK. the ECJ, or the European Court of Justice, has no jurisdiction within the English legal system. But following the accession of the UK to the European Union, it is important to the English legal system. As in, the ECJ, or the European Court of Justice, is called upon to provide interpretations on treaty agreements by the domestic courts itself. That was a brief outline of the various types of courts which are in effect within the UK.
Alright, welcome back to Legal Hour here on Free Time Television Network, Channel 35 with me, Bakarr, Marrah, and our topic of discussion tonight is the effect of public emergency in containing COVID-19, taking into cognizance human rights. And due to that, I have with me two eloquent guests, Mr. Ibrahim Bangura, Esquire from Legal Aid Board, and Mr. Macus, the Secretary General of the CSO Working Group on Epidemics and Natural Disaster. Well, we are about to bring the program down for tonight, and let's have we can have the last words or statement of my guest here last night. So, Mr. Ibrahim, being that we've discussed on the legal effects of public emergency, the rights of the president, the rights of parliament, and blah blah blah, and many other stuff being discussed earlier. So, what could be your final words for tonight?
Yes, my final words for tonight would be that myself sitting here, I'm a human rights lawyer. I believe in human rights, and more especially when the Constitution guarantees and provides for them. However, as I stated earlier, these are not normal times. A situation is existing in our country which has the tendency to bring this country to a shutdown. I verily believe this is a global pandemic, this is a national pandemic, and rightly to speak, the president has such a right as provided by in Section 29 to declare a public state of emergency and to make such regulations and to, in his opinion, to make such rules as are necessary and expedient to him to curb and fight this very, very bad situation. I would like to admonish the general public to comply with such regulations, whatever in whatever form or shape they come, be they legal or illegal. But I may like them to be legal, as my friends say. But to be more serious, these are hard times. We are fighting an enemy which we are not seeing. I call it a kind of war. We are fighting. We are in a war, a state of war, and these are some of the circumstances under which, as provided by Section 29(2), the president is empowered, authorized to make such a declaration, and rightly so he has made. And I believe, as a human rights lawyer, the Constitution has guaranteed and protected the rights of individuals. However, those rights, in times like this, they are curtailed, they are being suspended, and we should not be short-sighted to that fact that these are not normal situations. Okay. Should any citizen is aggrieved or has concerns about legality or illegality, I encourage them to channel those rights or concerns to the court of law.
Thank you very much, Mr. Ibrahim Bangura, Esquire. It's nice having you in my studio, and I also hope to have you in my subsequent programs.
Thank you very much.
I'm now to Mr. Macus Bangura, the Secretary General of the CSO Working Group on Epidemic and Natural Disaster. So what could be your final words for tonight?
I want the people of this country and the authorities concerned to know that the CSO Working Group for Epidemics and Natural Disasters was established to complement government efforts. We know that government has been working assiduously to ensure that we defeat COVID-19. So it is in that spirit that we formed the consortium, and we intend to work in conformity with what government wants. when we talk about right, because we are very much concerned about the human rights aspect as well, in as much as we complement government efforts, we are also very much concerned for human rights to be taken into consideration when regulations and measures are being put in place. Because Chapter 3, Section 15, Subsection 1, gave fundamental freedoms to individuals in the country. But there are times when these rights could be restricted for the general good of all. That is why in the same Chapter 3, Section 15, there are also limitations, right? Subsection 2, 3 talks about limitations, that the rights can also be limited when it comes to issues that has to do with defense, that has to do with public order, that has to do with public health. So, for the best interests of the people of the country, the rights which the Constitution gave us will be restricted. However, we are calling upon the government, whenever rules and regulations are affected, the aspect of human rights should be taken into consideration in conformity with what the body rights of the United Nations stated, that they are expecting government and they admonish government to ensure that whilst they make these measures, they should respect fundamental human rights. And respecting fundamental human rights, they should take into consideration of certain things. For example, you look at health facilities, there should be access. Even when we have lockdown, they should create a situation where individuals should have access to health facilities. Pharmacies, you understand? Pharmacies. Then also, with other things that should be taken into consideration, you have people that are volatile, those that are physically challenged, you understand? They should be provided for. The homeless and all these things. During the lockdown, we endeavored to ensure that we provided food items to some of these vulnerable people in various societies. So as a result of that, the United Nations has made it very, very clear that government should yield to that. They should work to ensure that they provide a situation that will be good for those that will be affected. So, on behalf of the consortium, we are calling on the people of Sierra Leone to actually adhere to precautionary measures. The aspects of social distancing should be taken into consideration, because through my eyes, what I have seen, we are still turning blind eyes and deaf ears to social distancing. When you get to town, you see a lot of them, they are still, mingling around, which is very detrimental. So as a result of that, we also want the government to redouble its efforts and stand tall in the fight against COVID-19. Because if we fail to actually cripple it and roll it back, there is the proclivity that it will not only kill people, it will affect our economy to an extent that the future generation, will be caught in a web. And we don't want that kind of a web, you understand, to be faced by them. We have already faced it. So what is the situation that will be good for all?
Thank you very much, Mr. Macus Bangura, the Secretary General of the CSO Working Group on Epidemics and Natural Disaster. And I'm very much enticed to have you in my studio, and I also wish to have your subsequent programs.
You're welcome.
Viewers, this is how we come to the end of tonight's program of Legal Hour, but always keep glow of our frequent programs, because we're here to educate you about the law, to you be aware of your civic and political rights and other legal concepts. So be glued as I come with you another legal concepts in my next episode with different eloquent voice that will also educate you based on the law and your civic and political rights. So many thanks to my producer Tap, and this is how we come to the end of tonight's program. Thank you very much. Till we meet again. I am Marrah. Thank you. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, You are part of the law, because the law is made for you, and you must know the law. Thus we bring you the Legal Hour. Actors Lemony Pakait Injuria. The act of the law does no one wrong, but uphold justice. One of the most famous Latin legal presumptions of law is ignorantia legis neminem excusat, which means ignorance of the law is no excuse. Some of us do appreciate such legal expression, while others do not, on the basis of fairness and unfairness, justness and unjustness, morality and immorality. Whether you know the law or you do not, you are part of the law, because the law is made for you, and you must know the law. Thus we bring you the Legal